Welcome back to the deep dive. We've talked about cause and fact, that simple but-for test. Now we're diving into something much trickier, proximate cause.
That's right.
So if someone's action is a but-for cause of harm, why doesn't the law always hold them responsible? Why draw a line?
Well, because you have to draw a line somewhere. Otherwise, liability could stretch back almost infinitely. Think about that classic example Justice Andrews used.
Oh, the defective contraceptive one.
Exactly. A manufacturer makes a faulty contraceptive. A child is born who, years later, maybe 16 years later, drives negligently and causes a fatal accident. Technically, the manufacturer is a but-for cause. But is it fair or practical to hold them liable? Clearly not.
Right, the connection is just too remote. So proximate cause is about figuring out where that cutoff point is, the difference between a cause and the legal cause.
Precisely. And that's our mission today, figuring out how the law makes that distinction. Proximate cause acts like a policy gate. We'll look hard at the main test courts use now, the foreseeability test, and, importantly, its exceptions and limits. We'll break down the key cases element by element.
Okay, let's get straight into it. What is the main test for proximate cause used today? What are its core parts?
The dominant rule is a foreseeability test. Basically, it asks, should the defendant have reasonably foreseen, as a risk of their actions, the general type of harm that the plaintiff ended up suffering?
Okay, reasonably foreseen. And what are the elements you actually have to prove?
There are two key things. First, you need to show that the result or the type of harm was reasonably foreseeable. And second, you need to show there wasn't any superseding intervening force that came along and broke the causal chain.
Now, this is where it gets interesting, right? Because the law says the type of harm must be foreseeable, but not necessarily the extent of the harm or the exact way it happened.
That's a critical point. It prevents defendants from escaping liability just because the details were bizarre.
Can you give us that famous example, the one with the rat?
Sure. It illustrates the point perfectly. Imagine someone negligently leaves a lit flame right next to a gas outlet. Okay, an explosion or a fire. That type of harm is clearly foreseeable.
Right.
Now, let's say a rat gets its fur lit by the flame, panics, runs over to the gas outlet, and that's what causes the big explosion. That exact sequence, that manner of harm, is totally unforeseeable, bizarre even.
Yeah, definitely weird.
But it doesn't matter for liability. The defendant is still on the hook because the general type of harm, an explosion or fire from the flame near the gas, was foreseeable. The rat is just part of the manner.
So the cartoonish details don't get you off the hook if the general danger was obvious. Okay, this brings us to the big case that really established this foreseeability rule. Wagon Mound number 1. Let's break it down. First, what are the key facts?
Okay, Wagon Mound number 1. You have the defendant's ship in Sydney Harbor. It negligently spills a type of furnace oil into the water near the plaintiff's dock. The plaintiff's workers are doing welding on the dock. They actually stop for a bit and then start again. Hot metal falls, hits the oil in the water, and poof, the oil catches fire, burning the dock.
And the core legal issue. What was the precise question for the court?
The issue was the fire damage to the dock a reasonably foreseeable consequence of spilling that specific type of furnace oil onto the water?
What rule did the court use to decide this? Can you state the rule and its elements?
They explicitly adopted the rule that liability depends on the reasonable foreseeability of the consequent damages. So the main element they were wrestling with here was that first one. Was the result type of harm of the fire reasonably foreseeable?
Thanks. Now for the court's elemental analysis. How do they apply that first element, reasonably foreseeable result, to the facts in Wagon Mound number 1?
Well, this is where a crucial finding by the trial court came in. They found, as a matter of fact, that based on what was known then, the defendant's engineers couldn't reasonably have been expected to know that this particular kind of furnace oil could even catch fire when spread thinly on water.
Really? That sounds convenient.
It was perhaps questionable, maybe influenced by wanting to avoid finding the plaintiff contributorily negligent for welding, but based on that specific finding, the court said the fire consequence was not reasonably foreseeable, so no liability for the fire damage.
Okay, so a technical finding lets them off. But that wasn't the end of it, was it? Because another ship owner sued over the very same fire in Wagon Mound number 2. How did that turn out?
Right. Wagon Mound number 2 is where things get clearer policy-wise. This time, suing for damage to ships, not the dock. The court did find for the plaintiff. They clarified what reasonably foreseeable actually means. It doesn't mean the risk has to be probable or more likely than not.
Oh.
The court said if a risk, even a remote one, would cause significant harm if it happened, and there was no good reason for the defendant to run that risk, then it is foreseeable. They looked at the oil spill and said, look, any risk of fire, however small, was significant, and spilling oil served no purpose. Therefore, it was foreseeable in this context.
So putting both cases together, reasonable foreseeability isn't some fixed probability calculation. It's much more flexible, more contextual.
Exactly. It's about what a reasonably thoughtful person would consider in their actions. The fact the court could reach opposite conclusions on foreseeability based on slightly different evidence or framing in number 1 versus number 2 really shows how, well, malleable the concept is. It gives judges room to maneuver based on the situation.
That flexibility seems vital for its function as a policy tool. Okay, let's move to the second big limiter on liability under the foreseeability test, the idea of a superseding intervening force. What exactly is that?
Okay, so first, an intervening force is just some new force, could be other person's actions, an animal, an act of nature, whatever, that comes into play after the defendant's initial negligence.
Right.
It only becomes superseding, meaning it breaks the chain of causation and lets the original defendant off the hook if its occurrence seems extraordinary, really highly improbable under the circumstances. It has to be something well outside the bounds of normal expectation.
Let's use that gas station example. Someone negligently spills gasoline. Obviously, fire is a foreseeable risk. Then a second person comes along and negligently drops a lit match near the spill. Is that second person's negligence a superseding cause?
Probably not. A negligently dropped match near spilled gasoline at a gas station. While it's negligent, it's arguably not extraordinary or highly improbable in that specific context. It's the kind of thing that unfortunately might happen. So the original spiller likely remains liable.
Wait, but what if the second person intentionally lights the gasoline? Arson. Does that change things?
That's much more likely to be considered superseding. Intentional criminal acts are often, though not always, viewed as extraordinary and unforeseeable interruptions to the normal course of events. But again, it depends on context. Maybe arson is common in that area. Usually, though, intentional crime breaks the chain.
So the courts generally seem hesitant to call something superseding unless it's really out there, really unexpected. What about things like, say, medical malpractice after an initial injury?
Generally, ordinary medical malpractice following an injury caused by the defendant is not considered superseding. Why? Because it is considered a foreseeable risk that if you injure someone, they might receive negligent medical care. It's part of the risk you created.
Makes sense.
However, if the malpractice is truly extreme, like, say, amputating the wrong limb entirely, that might be considered so bizarre and unforeseeable, so highly improbable, that it would be a superseding cause, cutting off the original defendant's liability for the harm caused by that specific malpractice.
Okay. This leads us neatly to a huge exception, but only for personal injury cases, the eggshell plaintiff rule or thin skull rule. This one seems like it could lead to massive liability for defendants. How does it work?
It's a stark rule. It basically says, you take your victim as you find them. Once any physical harm to the plaintiff is foreseeable from the defendant's negligent act, the defendant is liable for the full extent of the physical harm the plaintiff actually suffers, even if the extent or the specific type of harm was totally unforeseeable because the plaintiff had some hidden vulnerability.
Let's paint a picture. A negligently bumps B on the head. Normally, this kind of bump would just cause a minor bruise, but unknown to A, B has this incredibly rare condition, like an eggshell skull. The minor bump causes a catastrophic brain hemorrhage. Is A liable for the whole catastrophe?
Yes, absolutely. A is fully liable for the catastrophic injury. It doesn't matter that A couldn't possibly have foreseen that specific vulnerability or the extreme extent of the injury. Some physical harm was foreseeable, so A pays for all of it.
Wow. And does this apply just to physical conditions?
No, and this is where it gets even more controversial. It also applies to pre-existing psychological vulnerabilities. So, a minor car accident that might just shake up an ordinary person could trigger a complete psychotic break in someone with latent schizophrenia. Under the eggshell plaintiff rule, the defendant is liable for the consequences of that psychotic break.
That's quite something. It feels like a throwback, doesn't it? You mentioned earlier rules.
It does. Many see it as a holdover from the older direct causation test, which cared less about foreseeability and more about the direct chain of events.
Since you brought it up, let's rewind. Before foreseeability became dominant, there was this direct causation test. What was its basic idea?
It was much simpler, almost purely mechanical. Foreseeability didn't matter. The rule essentially was, If your negligent act was the direct cause of the damage, without any new force intervening, you were liable. If some new force came into play, you weren't the direct cause anymore.
Okay, let's look at the case that embodies this. In Re Polemis, what were the key facts there?
Right, Polemis. Defendant's workers were handling cargo on a ship. They negligently dropped a heavy wooden plank into the ship's hold. As it fell, the plank somehow caused a spark.
A spark from a wooden plank.
Apparently so. Maybe it hit something metal. The hold happened to have petrol fumes that had collected there. The spark ignited the fumes, causing a massive explosion that destroyed the entire ship. Critically, the court accepted that this explosion, this consequence, was not foreseeable from merely dropping a plank.
Okay, unforeseeable explosion. So what was the core legal issue?
The issue is straightforward under the old rule. Was the defendant's negligent act, dropping the plank, a direct cause of the ship's destruction, even though that destruction, the explosion, was unforeseeable?
And what rule did the court apply?
They applied the direct causation test. The key element they looked at was there an intervening force between the plank drop and the explosion?
How did the court analyze that element? Was there an intervening force?
The court said no. The spark, the ignition, the explosion, it all flowed directly from the single negligent act of dropping the plank. No new force came into play between the drop and the fire. It was one continuous, albeit unexpected, sequence of events.
So, the final conclusion?
Liability. The court held the defendant liable for the full value of the destroyed ship simply because their negligence was the direct cause. Foreseeability of the damage was irrelevant. This ruling shows the stark difference under direct causation. You could be liable for utterly freak results, as long as the chain wasn't broken.
And of course, we know Wagon Mound later came along and explicitly rejected Polemis, shifting the focus firmly to foreseeability as the main test.
Exactly. It marked a major shift from a physics-based rule to a more policy-driven one.
Which brings us back to policy. Justice Andrews called proximate cause practical politics a rough sense of justice. How have the restatements, those big summaries of law, tried to capture this policy element?
Well, the restatement, Second of Torts, used the term legal cause. It incorporated the substantial factor test, but it still had a policy check. It said liability might be cut off if, looking back from the harm, what they call hindsight or prevision, it seems highly extraordinary that the defendant's conduct led to that particular harm.
Still sounds a bit fuzzy, highly extraordinary. What about the more recent restatement?
The restatement third moved away from legal cause and substantial factor. It prefers the term scope of liability. Its core idea is that liability should be limited to harms that result from the risks that made the actor's conduct tortious in the first place.
Can you give an example of that?
Sure. Think about leaving a loaded gun where a child might find it. The risk that makes that negligent is the child accidentally shooting someone. That's the tortious risk. If instead the gun falls off the shelf and breaks someone's toe, well, that harm didn't result from the specific risk, accidental discharge, that made leaving the gun there wrongful. So, under the restatement third, there might be no liability for the broken toe, even if leaving the gun was negligent for other reasons. It essentially aligns very closely with the modern foreseeability test, just using slightly different language.
Okay, that's a helpful clarification. Now let's bring it all together. For someone facing a law exam or needing to analyze a proximate cause issue quickly, what's the practical step-by-step checklist?
Right, here's a quick diagnostic framework.
Perfect.
Step 1, actual causation check. Always start here. Was the defendant's conduct a but-for cause? If not, you're done. No liability.
Got it.
Step 2, proximate cause rule foreseeability test. If but-for cause exists, apply the foreseeability test. Was the general type of harm that occurred, like fire, physical injury, property damage, reasonably foreseeable as a result of the defendant's conduct? Remember, not the specific manner or extent.
Okay, type of harm foreseeable.
Step 3, eggshell plaintiff exception. Check if the harm is personal injury. If it is, ignore the foreseeability of the extent or the specific type of that personal injury. Apply the rule. Take your plaintiff as you find them. Defendant pays for all harm, even unforeseeably severe harm.
Right, the big exception.
Step 4, intervening force check. Was there some new force that came into play after the defendant's negligence? If yes, ask, was this force superseding? Meaning, was it highly improbable, extraordinary, almost bizarre under the circumstances? If yes, it breaks the chain, and the original defendant's liability is cut off, at least for harm caused after the superseding force. If no, the defendant remains liable.
That's a really clear, actionable checklist, thank you. So wrapping up, We've seen that proximate cause isn't just about physical chains of events, it's the law's essential tool for injecting policy ideas about fairness, who should bear losses, preventing excessive liability into the causation analysis. It limits the potentially endless reach of but-for cause.
Absolutely. And maybe the final thought is this. Notice how much judgment is involved, especially in deciding what counts as a foreseeable type versus an unforeseeable manner or what's highly extraordinary. This inherent flexibility, this malleability, is maybe the defining feature of proximate cause. It gives courts the room they need to reach results that seem just and fair in the specific circumstances, effectively deciding who should bear the loss, without always having to spell out every single underlying policy reason in the opinion. It's where law meets policy, often subtly.